For those that don't know me, I'm Nick, and I head the employment team at Actons. Actons is based out of Nottingham. We service clients across the UK, so we're centrally located for that, and we work with a whole range of different clients, including some household names that you'll have heard of, and a number of amazing SME clients too. We also help out with the odd settlement agreement, and there's been a few of those recently. There seems to be a bit of a surge of people leaving organisations. So that's me. You'll hear from some of the team today. We do quite a bit on LinkedIn, so anybody that is connected with me will know that there's various mildly humorous posts as well as some updates, and the other guys, Laura and James, who you'll hear from later, tend to cover some proper employment law and serious technical information. So take your pick, I guess, is my suggestion. And if you have a smartphone handy, you can scan the QR codes there, and that will link you to our profiles on LinkedIn. I think increasingly we're seeing people engaging with us there, because there's so much changing in employment law at the minute. So it is worth popping there every now and again, just to check in on the latest. We also have a newsletter that you can follow there, and you can get on our mailing list for a similar newsletter too. Laura in particular would love you to connect with her, because we have a bit of a competition as to how many connections she can get. In terms of working with you, as I talked about, there's a lot's changing. The Employment Rights Bill is progressing through Parliament, and in fact I posted this morning with an update on that, so feel free to check that out for where we are with it. But it's coming, and if you need help in preparing for the Employment Rights Bill, there are various things that you can start to think about. Not massive changes, but things that you can do to try and get ahead of what's coming. Then do reach out to us. I think Matt's going to post a link to that sort of brochure in the chat for you, so you can take a closer look if that would be helpful. The other thing that I have the pleasure of doing is hosting something called the HRD Talks podcast. And if you've been on any of our sessions before, you'll know that we always like to give it a plug. The latest episode was with Jan, who's really open about her own health challenges, but talks really eloquently about leadership and leading people through change. And it's a great episode. It's one that I'm really proud of, and I'm really pleased that Jan agreed to join me. So if you want to, again, there should be a link hopefully coming via Matt in the chat to those episodes on our website, but you can pretty much find it on any of the podcast services that you might be using in order to listen to podcasts. So just search it up, or in fact ask your smart device to find it, and it'll play it for you. My kids are regularly doing that just to listen to the music, is what I've been told, along with my mum, who's a regular listener. So in terms of this morning, we're going to just give you a quick overview of what we're going to talk about. And what we thought would be helpful is just a recap on discrimination law and how it works. So Laura and James are going to kind of take us through the basics of the different types of areas of discrimination, or different types of claims that can be brought, because it's all very helpful to talk about the latest trends or latest cases and that kind of thing. But actually it is important to have a kind of at least basic understanding of how this stuff works from a legal perspective, because it will allow and inform your decision making within the workplace and your kind of risk assessment of certain situations, which I think is helpful to do. So we're going to do a bit of a recap on that. We're also going to look at the Supreme Court decision recently on the definition of a woman in the Equality Act, and I'm going to pick up that. We're also going to look at menopause, because we're seeing increasing number of cases and inquiries about that. And then we're going to look at religious and philosophical beliefs and that particular type of discrimination. At the end, we'll have some time for questions, and if there's anything else that's a kind of burning issue for you that we haven't covered, then obviously we can pick that up then. Again, with these sessions, what we try and do is set a bit of the context. Why are we even talking about this? Well, equality, diversity, and inclusion has kind of been in the headlines a lot recently, particularly in the US, with a new president who certainly has a particular view of how these things should work. And it's certainly, I think, leading to a bit of a rollback in the States around these kinds of initiatives and the focus on it certainly from a positive perspective, I think it's perhaps being viewed more negatively. So often trends in the US tend to follow over to the UK eventually. And I suppose there's a question mark on that first bullet point, because it may be that that's the way that we head, but obviously that's open for debate and we'll see what happens. The other reason that we think it's important to talk about this particular issue is two risk areas, I suppose. So both an increase in tribunal claims, and we're seeing a bit of a trend of that recently. We're certainly dealing with more of those for clients, and they have tended in recent years to be much more discrimination focused as opposed to the kind of bog standard unfair dismissal type claims. There's nearly always a discrimination element in the tribunal claims that we're getting through these days. But also PR is particularly important for employers in recent times, because employer brand's really important, and the impact that a PR issue can have on a business and the damage it can do is pretty significant, particularly when everybody's a journalist. They can get on Twitter, X, LinkedIn, Facebook, Glassdoor, whatever it might be, and express their views about a workplace and employer, and that can be quite damaging, particularly if it's a discrimination issue that is involved. And of course, I've already mentioned there's new law coming. There are various things that we'll touch on briefly as we go that may be impacted in the future with the Employment Rights Bill. We do have other sessions that we've done, which again you can see on our website in the Knowledge Hub on the bill specifically. But again, LinkedIn's probably the best place to keep track of what's going on in terms of the updates on that. So lots changing, lots to think about, but hopefully we'll guide you through some of this today and you'll be better prepared. So our starting point, I think I'm handing over to Laura, and she'll talk us through some of the claims.
Brilliant, thank you, Nick. Morning, everybody. So as we're saying, the starting point is we'll be running you through some of the main types of discrimination. So on the slide that you should be able to see now, we've got the four main types: direct, indirect, harassment, and victimisation. So I'll be going through a quick run through of what we mean by discrimination under the Equality Act 2010, including a brief look at who's protected, who's liable, and any exceptions to that. So direct discrimination then. The wording on the screen that you can see in front of you is a direct take from the Equality Act. So direct discrimination occurs where, because of a protected characteristic, A treats B less favourably than A would treat others. So I know most of you on this call will be familiar with the term protected characteristic, but just in case anyone's not, we're talking about the list of characteristics in the Equality Act that people have protection. So things like age, disability, race, religion, belief, etc. So a person claiming direct discrimination should seek to show that they have been treated less favourably than either a real or a hypothetical comparator, as you'll see on the screen. There is one exception to this, so pregnancy or maternity discrimination doesn't require a comparator, but everything else does. So in general terms, a comparator is a method that the tribunal use to compare the treatment received by the claimant to somebody else who doesn't have that protected characteristic. So without the existence of that protected characteristic, the circumstances aren't materially different to themselves. So they're comparing essentially like for like as best as they can. Broadly speaking, we're talking about someone who performs pretty much the same role as a claimant. So it is commonplace in direct discrimination claims that we see for a claimant to name another employee or group of employees and identify them as the comparator. So for example, a claimant brings a claim for race discrimination and identifies someone that's a different race to them, and they say, well, I'm being treated less favourably than this person. Now, obviously, in some circumstances, it's not always going to be possible for someone to actually point out somebody who is a real comparator and say, it's this person that I'm talking about. For example, a small business where everyone has very different roles, or simply there is just no comparator that they can pick out. So in those circumstances, they can use a hypothetical comparator. So usually where a claimant brings this type of claim, whilst they don't always explicitly say, this is my comparator, this is who I'm comparing myself to. Usually from the claim form, we can pick out what it is they're saying that they're comparing it to, and it might be something as simple as, I think I've been treated differently to my colleague because I'm a woman, and we can try and get to the bottom of that. And obviously it can be clarified as claims go through, and I think any of you that have had experience of seeing discrimination claims go through the tribunal, you will know that quite often we're unpicking details as we go through in preliminary hearings and things like further and better particulars as we go through, with the ones where we start to actually get clarity on all of those things. So whether or not the person's a real comparator comes up quite a lot, but obviously if we're in a circumstance that we were defending a claim for you, that's something we could talk about with you at the appropriate time. So direct discrimination, for the claimant to be successful in their claim, the less favourable treatment must be found to be because of that protected or of a protected characteristic. So the tribunal look at and consider the reason why. So why was the claimant treated less favourably? To do this, they listen to all sorts of evidence, and again, if you've been involved in those types of claims, you'll know that witness statements and disclosure of documents, etc., are crucial to getting that sort of done. So the tribunal will hear evidence on those points, and they will assess and consider the conscious and subconscious reason behind the treatment. So what led person A to take that particular course of action or treat person B in the way that they're alleging. So what was influencing that decision? What was the thought process behind it, what played a significant role in what happened, essentially. So there's a couple of interesting things here. Well, I say interesting, perhaps vaguely interesting, if you're an employment lawyer or you like these kind of things. In most cases, and there is an exception, but I'm not going to confuse matters with that, but in most cases, the less favourable treatment doesn't necessarily have to be because the person has a protected characteristic. So, for example, it could be that an employee without a disability could bring a direct disability discrimination claim where they've been treated less favourably because they have a disabled child, for example. So that's one thing that always surprises a few people. And there's also the one where, and if an employee is wrongly perceived to have that protected characteristic, then they're also protected. So, for example, an employer may wrongly perceive that their employee is Muslim, and the employee might then have a direct discrimination claim if they think they've been treated less favourably because they've been perceived to be a Muslim or any other protected characteristic. And as you'll see on here, the alleged discriminator's protected characteristic is irrelevant. So we do hear a lot things like, well, I'm a woman, so why would I discriminate against this woman? That defence isn't going to work, to put it mildly. The tribunal is still going to want to hear and consider the evidence on the reason why, and they're still going to be looking into the subconscious reasons and the conscious reasons behind what people have done and what's happened in the claim. So generally speaking, except for those on the slide, so age discrimination and potentially certain religion or belief cases, direct discrimination can't be objectively justified. So in some situations, an employer may be able to rely on exceptions within the Equality Act that, if applicable, and definitely something that we'd be saying, get some advice on or come talk to us about before you do, but some may make that kind of direct discrimination lawful. So if, for example, a male applicant not being appointed because a female was an occupational requirement for the job, these type of circumstances are fairly rare and fairly niche, and like I say, it's not something that we'd suggest just doing off the top of your head. So the less favourable treatment must amount to a detriment, as we've said. It's not enough just for someone to say, I think I've been treated badly. The claimant has to explain, okay, well, what impact has it had on them? So has it resulted in lower pay? Has it resulted in lower hours? Have they been looked over for promotions or development opportunities, etc.? And of course, the tribunal then look at the evidence on that one to see, as we've just said on the previous slide, well, actually, was that because of their protected characteristic or was it something else? So then the other main type of claim is indirect discrimination. So that looks at things that happens in the workplace. So we often talk about things like policies or practices that are not intended to treat anyone less favourably, but when actually in practice and in reality, they do have the effect of disadvantaging people with a particular protected characteristic. So again, the wording that's on the slide in front of you, and I'm not going to read it all out to you, is taken directly from the Equality Act. But essentially what we're saying is that there's a provision, criterion or practice, which is commonly referred to as a PCP, and that gets put into practice and inadvertently, in essence, puts somebody or a group of people to a disadvantage. So Identifying what that PCP is obviously a fairly fundamental step in bringing such an indirect discrimination claim. PCP does have a fairly wide meaning, so employers' actions can be challenged in an indirect discrimination context, even where there is no formal policy in place. So it could just be there is a daily practice that this happens, and that is being challenged. So usually a claimant will point to something that happens in practice that they say causes them or people that share their protected characteristic a disadvantage. So an example might be, for example, that an employer states that all employees must work in the office full time. Then you look at what the particular disadvantage of that to the claimant and the group is. So indirect discrimination is a group-based claim. So the PCP must put people who share the protected characteristic at a particular advantage. So in this example I just gave, women, it has to put all women in that group to the particular disadvantage. So if the requirement to be in the office full time, for example, was there, it could disadvantage women who, rightly or wrongly, even in 2025, still bear the greater part of domestic childcare responsibilities, etc., than men, and are therefore more likely to want and need flexibility and working around part-time, flexible ways, etc. So unless the employer can objectively justify the need for there to be a full-time worker or somebody physically present in the office full-time, the requirement therefore might be indirectly discriminatory against women with childcare responsibilities, etc. And that's just an example of something that actually might be seen as, well, actually we do require everybody to be in full-time in the office, that's not a problem, but actually does result in putting a particular group of people to a disadvantage, or potentially could do and could be argued that way. I think I skipped on one there, sorry. So I'm now going to hand over to James, who's just going to have a run through the other couple of things for you.
Well, thanks, Laura. I'm just picking up the last two main types of discrimination claim. And the first thing we need to consider, a very important matter, is how we pronounce this. Is it harassment or harassment? We've had a big debate in the office as to which it is. It's a shame we can't put hands up, but stick in the chat what you like. Are you a harassment or a harassment person? Or is one of them American? Who knows? But this is quite a common one in claims that we see, often dovetails with direct discrimination for reasons that you'll probably work out as we go through. The first one I said, harassment. Harassment. So, as usual, a mixed bag. There's never an agreement on this. But anyway, the definition, as Laura alluded to with her examples, is taken from the Act, so we haven't made that up. And harassment, I'm going to say that now because that's the one less people say, is quite complicated, and there's lots of strands to it. So if we take it in turn, firstly, there has to be a person engaging in unwanted conduct related to a protected characteristic. And then it has to do one of two things. It either has to be that it's done for the purpose of violating dignity or creating a hostile, degrading or humiliating environment. If it does that, then you've ticked that box. But if it wasn't intended or didn't have that purpose, you then look at the effect. I'd say often effect is more common, but you do see purpose ones as well. So it's either or. You look at purpose first. If you don't tick the box on purpose, you move on to effect. There is no need for the victim to make the perpetrator aware that the conduct is unwanted. So it won't necessarily be a defense for the person who's the alleged harasser to say, oh, I didn't realize it was unwanted. Some of the time then that should be apparent, or they should just know that conduct unrelated to a protected characteristic is likely to be unwanted. So there's a bit of personal responsibility there. And when deciding whether or not something constitutes harassment, there's a kind of a mixture of subjective and objective tests that the Employment Tribunal looks at. What do I mean by that? Well, when you're looking at this unwanted conduct and you're deciding whether it has the effect of creating the violation of dignity or the hostile, degrading, humiliating environment, firstly, you look at the perception of the victim. So that is a subjective element. How did they feel and why? You also look at all the surrounding background and circumstances of the case. So that might be the personal circumstances of the victim. It might be who the alleged harasser is. Is it a manager, for example? Is it a person in power? That might make a difference than if it's just a colleague. And then finally, you look at whether it's reasonable for the conduct to have that effect. So could the person who's claiming harassment reasonably say that the conduct had the purpose of violating their dignity? And sometimes there's an argument surrounding that for things that are perhaps more innocuous. Although I would sort of caution against running the hypersensitivity argument too much. It can be a bit unattractive into the tribunal where you've got something that really isn't that appropriate a conduct for you to argue, well, yes, it wasn't quite right, but they didn't really upset them, did it? When they're giving the opposite case. But it is an argument you can run if appropriate. Now, one big difference between this and direct discrimination, the less favourable treatment because of the characteristic that Laura alluded to, is that you don't need a comparator for harassment. It just needs to be, the unwanted conduct just needs to be related to a protected characteristic, which is looser. I've said a couple of times related to a protected characteristic. Well, what do I mean by that? Well, it's wider than the because of test, the reason why tests that Laura alluded to. So, for example, if I just enter the office and indulge in some generally sexist banter that isn't really aimed at anyone in particular, because it relates to a protected characteristic, people who hear me say that could be offended. It could create the effect of creating the hostile environment that was on the previous slide, and therefore amount to harassment. So, or harassment. So it is wider. So it's often claims you often see are argued as either being harassment or direct discrimination by claimants, because what the tests are slightly different, and certain facts could meet either test, and claimants, if they're well advised, often hedge their bets. However, a word of caution, there must be a connection between the conduct that is being complained of and the protected characteristic. An example that I thought was quite interesting from the case law is a case of Raj and Capita. You've probably heard of Capita. And it involved a female team leader massaging a male colleague's shoulders. That was held not to be harassment on the basis it didn't relate to a protected characteristic. It was just misguided encouragement. I mean, the fact that that example went to a hearing suggests that it was probably finely contested. And so I'm not suggesting that that's a practice that perhaps people should indulge in because it puts everyone at risk of claims. But it just goes to show there is this detailed analysis of the facts and the, was it related to the characteristic? Was the conduct related to the characteristic? Here they said the fact that the two people are men and women, that wasn't related to that. It was just encouragement. And presumably the massage would have been doled out equally to any good performer or whatever it was that justified the massage in that person's view. Second bullet point is an important one. One-off or single acts can be harassment, but there must be a degree of seriousness. I think that it's kind of common sense reading the language that a one-off act could constitute unwanted conduct, because a one-off act could be very serious or it could be very minor. And a degree of serious is not an especially high bar. You still go back to the test on the previous page. Does it create that effect? And in the circumstances, taking into account the potential victim's perception, was it reasonable to have done so? So not an enormous bar there. So moving on, if I flick over the slides, only one way to say victimization, and it's where a person subjects another person to a detriment because the second person, B, has done a protected act, or A, thinks they have or might do one. So that beggars the obvious question of, what do I mean by protected act? There's a few. Usually, from a practical perspective, it's the last one, which is alleging, somebody alleges, whether expressly or otherwise, that somebody else has contravened or breached the Equality Act. Also covered would be bringing proceedings under the Act, giving evidence in connection with proceedings under the Act, or doing any other thing for the purposes of or in connection with the Equality Act. I mean, the one you see in practice is where an employee accuses someone of discriminating, harassing, or something similar to that. That's your usual protected act. I mean, you do see others, but they're the kind of common ones. So once you get over that hurdle, what are we looking at? Well, there's actually no requirement for anybody to have the protected act. So the person making the complaint could be complaining about something else. And it doesn't matter what the alleged victimizer's characteristics are. So that's slightly different. Unsurprisingly, there's no comparator needed because it's going to be very unlikely. You don't need one, but if you think about it, it'd be unusual if two people made the same complaint. But even if they had, it doesn't matter. And the thing that we always call the causation test, the why did something happen, the detriment that you need to succeed in the victimization case must be because of the protected act. So timing is all important. We do see this on tribunal claims where someone says, well, I complained about victimization and I complained about a breach of the Equality Act and I was victimized. And then you ask them what the detriment was they suffered in the victimization claim, and they point to something that happened before they made the protected act. And that's a death knell of the case. The detriment must be after the protected act, because if it isn't, it can't have been because of it. And you'd be amazed how many times these claims are pursued and you gleefully kill them off at the preliminary hearing stage on the basis that it can't possibly be the case because the protected act came after the detriment. Similar point that Laura made applies for victimization. The protected act need not be the sole or main reason for the treatment. It just needs only be one of the reasons. And it need not be consciously motivated. You again look at the subconscious motivation of the person who's alleged to have victimized. Sometimes in victimization claims, you need to look at this slightly strange concept of separability, where the treatment can be separate to the protected act, but connected. That might sound strange. So the best thing to do is to give you an example. And there was a case of Woods, I think of Hassab, I think was the name of the business, and Woods, where a Muslim employee was dismissed for complaining that the respondent's business was, quotes, a little Sikh club. It was actually held in the employment tribunal that the claimant was victimized because he made an allegation that it was a little Sikh club, and then he was subsequently dismissed. But the Employment Appeal Tribunal overturned that finding and separated the comment that was made, the little Sikh club comment, and said that was an offensive racist comment, and that was the reason for the dismissal. So they separated the fact that he made an offensive comment from the fact that he was raising an allegation of discrimination, which would be a protected act. So he separated out the two. So sometimes there can be a fine analysis, because you might often see sometimes with individuals, they think if they raise a protected act, that insulates them from any subsequent treatment as a sort of strategy. It doesn't necessarily. Clearly, you need to be careful, and I'm not advocating that everyone victimizes, but you can see here in that circumstance why the employer wouldn't have been happy with that comment and why they would have wanted to do something about it, because it wasn't a mere suggestion that they'd been discriminating. It was an offensive remark, and the two could be separated from one another in the eyes of the tribunals. Well, the appeal tribunal at least. And final sort of point of the basics before we get onto the more complicated examples that Nick's going to look at, and then briefly I'll touch on at the end on the context of religion and belief. Who is liable for discrimination? So in all the previous slides, you had the reference to A and B. And A and B in all those examples were people. They weren't the company. So it's worth bearing in mind that any discriminatory acts which are done by an employee, so in all these examples, either the A or the B, in the course of their employment are treated as having been done by the employer. And so employers are effectively liable for the discriminatory acts of their employees when they are done in the course of employment. So you have to be wary that you could be liable for the actions of essentially someone who goes a bit rogue and does something that you wouldn't condone. There is an exception to that, the second bullet point. This is what lawyers refer to, and you might in the HR world as well, refer to as the statutory defense, where employers can avoid liability if they can establish that they took all reasonable steps to prevent the employee from doing the discriminating act in question or from doing anything of that description. Now, it's a notoriously difficult argument to succeed on, mainly because of the word all. and then the way that the case law over the years has interpreted that all. And as the second little sub-bullet point says, the defence will fail if the tribunal determines that there were other reasonable steps that the employer could have taken in addition to the ones that they actually did take. An argument that is often run and sometimes fails, and that famously is in the case, is we put our employees through extensive equality and diversity training. Now, in one case, that argument failed on the basis of the tribunal held that the training was 2 years old and therefore was stale, and the reasonable step they could have taken but didn't was refresher training. So that's just an example of how tricky it can be. That's not to say you shouldn't aim for it, but it's a defence that's difficult to succeed on. And what tribunals look at is the cost and effectiveness of the steps that employers could have taken when assessing reasonableness. And that will impact, and it will vary depending on factors like the size of the organisation, for example. Also important to note that the reasonable steps must predate the act of discrimination. So, for example, if an employee raises a grievance saying they've been subjected to an act of discrimination, whilst it's clearly a good idea to do a really good and thorough investigation of that grievance, and that may assist you with a reasonable steps defence on other cases by saying you've got robust management, it's not necessarily going to mean you succeed with the case, because the reasonable steps must predate the act. So just because it's not your fault and you did a good job in the subsequent dealing with it, that doesn't mean you'll make out the reasonable steps defence. You'd have to establish that you, for example, done appropriate training and people are aware of what they are not supposed to do. So it's a tricky one. And then finally, in terms of who is liable, it's worth bearing in mind also on the A versus B with scarce employees, that when you're bringing a claim of discrimination, you can pursue the discriminators, so the employees, your colleagues. So whilst the employer is, as the slide says, liable for the acts of the employee, that doesn't take the liability away from the individual. So it's often a tactic that the person bringing the claim will sue the colleague and the company. And if, for example, they were awarded £10,000 injury to feelings, the two parties would be both liable for that sum. The employee wouldn't get it twice. They'd only get their one lot of hurt feelings, but the employee could be liable. And sometimes employees being aware of that might be an incentive not to discriminate. Then finally, third parties. What happens if third parties harass your employees? Well, at the moment, nothing, in terms of you can't bring a claim in the employment tribunal on the basis that a third party has harassed you. But the big sort of flashing health warning is perhaps not for long, based on the Employment Rights Bill going through Parliament. So keep an eye on that one. And as to how the details of third party harassment will work, that will be a seminar for another day, I'm sure. And now over to Nick for the complicated bit.
Thank you, James. I guess a couple of lessons from James's section. Keep your equality and diversity training up to date. We can help with that. And I suppose the one that everyone will remember is be careful of your motivation when massaging colleagues, or perhaps just avoid it altogether. So let's get into the kind of the main sections for this morning. This one has attracted a lot of press coverage, and we acknowledge that it has sparked quite a debate and a lot of strong feeling on both sides of that debate. In fact, just describing it as two sides to the debate is probably massively over simplifying things, and therefore we are effectively looking to kind of set out the position as it stands following the Supreme Court decision, and we're not necessarily giving a view on whether we think that it's right or wrong, or our personal view on it, or any of those kind of things. But we thought it was helpful, just from an employer's perspective, to be setting out, okay, what did the court do here, and what did they interpret the law to mean? And in terms of the background to this, it was a case that originated in Scotland, and it was for Women Scotland versus Scottish ministers. And in my preparatory reading for the session, I realized quite how many different and complicated aspects there were in the build-up to this, but there were a whole variety of different challenges, mainly relating to stuff that the Scottish government were doing. And one of those kind of eventually brought us to the Equality Act, and that eventually made its way to the Supreme Court, and they were asked to determine a fairly distinct issue, but an issue that clearly has had significant kind of impact and a follow-on. And that was whether a person with a gender recognition certificate, so that's somebody who's transitioning, that recognizes that their gender is female, is considered a woman for the purposes of the Equality Act. And the decision that the Supreme Court came to was that the answer was effectively no. And for the purposes of the Equality Act, the term woman referred to exclusively biological sex that was assigned at birth. So that was their interpretation. And again, if you're really interested in this area, you can read up on that decision and all the different things that they considered. And understandably, they considered a lot of different aspects to this, but they came to the view that was the appropriate interpretation of the definitions within the Equality Act. That obviously, again, as I said earlier, attracted a lot of press attention, and it has had a significant impact, I think, on a number of people. And for the purposes of employers, it has affected certain sectors, certain industries, I think, more than others. And I think one of the things that I posted about, in fact, I did a little video when the decision came out, which went on to LinkedIn, was that employers shouldn't panic as a result of the decision. And that was because actually for lots of employers, it's less relevant, and it's not an issue that they're even having to consider. But for other sectors, particularly where employers are providing single-sex services, like women's refuges, or hospital wards, certain sporting facilities, that kind of thing, then it will be relevant. And it's important to come to a view, I suppose, in terms of how you're going to manage this issue. But I think the decision, the key aspect of it really has been that it is lawful, as the law stands at the minute, to exclude transgender individuals from services that are provided for biological women. Now, for most employers, the main query seems to have been around toilets, and what facilities can be made available to various people, essentially. And that, I think, is the one that most employers have been grappling with, where it's a relevant issue for them. Now, the Equality and Human Rights Commission, quite quickly, although I think there were some that would have said it was too slow, released some interim guidance on this to help employers and service providers. But it was quite heavily criticised, and I think understandably it was short and it was released relatively quickly. So there hasn't been a lot of time and thought necessarily gone into that. They are working on further guidance for employers. I think we have a link to the guidance that exists at the minute, which Matt will pop into the chat. But the consultation, I think actually is a typo potentially on the slide. I think it closes on the 30th of June. So there is still time, I think, to get a response to that consultation in, if you would like to. I think they've had at least 5,000 or so responses to that already. And as part of that consultation, they're then aiming, I think, to release a code of practice in the autumn, which will give further guidance in this area. I think for the moment, you have the guidance that Matt's kindly popped in there, and I've highlighted just a couple of bits. Effectively, it kind of repeats what I've just said, or I repeat what it says on the previous slide in terms of how employers and service providers can approach this issue at the minute. But it does suggest that, and I think I've lifted the quote on that final slide, that generally this will all work on trust, openness, and honesty, with proportionality lying at the heart of decision making, carefully balancing the interests of different groups, which to me is them acknowledging that this is incredibly complicated for some employers and for some service providers, and that there isn't necessarily an easy answer, and essentially, we're going to have to balance the rights of various groups when assessing what to do for the moment. And in terms of what the actual impact here is, I've covered the fact that it does lawfully allow certain exclusion, but I think the thing to remember too is that trans people are still protected under other aspects of the Equality Act, and that is a protection in itself. But I think it's also important as a kind of next step to consider, as it stands, based on the guidance that we have, do your internal policies on a variety of different subjects potentially, do they make sense given this decision? And are you clear that you're happy with the approach that you've taken? So it may be that nothing actually needs to change, but certainly having a look at what your policies say and having a reminder of that would be a good idea, just to check that you've been through that process. And I think also a bit like I'd said with the video when the initial decision came out, I think making more of an issue around this and creating anxiety for people obviously isn't a good idea if actually there isn't a massive problem in your workplace, for example, where you have toilet facilities that are open to everybody, or the ability to allow facilities for different groups of people in different parts of the building. So I think it's kind of watch this space to a certain extent, because I think the guidance will be updated, and the codes of practice hopefully will help clarify more of what employers and service providers need to do. But for the moment, it's about trying to take a sensible approach and being considerate and respectful of all groups, I suppose, at the minute, in order to navigate this in the interim period of time. Second issue that we wanted to talk about today in this section was menopause. And I guess a bit of a personal one on this section from my perspective. I actually shared mine and my wife's, Mrs. Elliott's, experience of menopause recently on LinkedIn, and there's a post I think Matt again will share. It's had an incredible response. You probably can't see it on the slide, but a huge amount of engagement in terms of people sharing their stories. And again, if it's an issue that you're interested in or that's relevant for you, it's definitely worth getting into the comments there and hearing people's experience of this, because it's genuinely really enlightening to hear those personal stories. Obviously today the idea is to focus on how employers can approach this, and I think there's still lots of work to be done in that area. And one of the interesting things was when I posted that and responded with comments asking people, what can employers do, it still doesn't feel like there's that much kind of guidance and that much assistance and that much kind of understanding as to how that will actually operate. Victoria's put a kind comment in the chat. Thank you, Victoria. So I think we're going to whiz through. We're going to have a look at some more of the detail on this and how it works in terms of discrimination law. And then we'll look at some cases and yeah, some tips for managing this issue in the workplace. So menopause in itself is not a protected characteristic. Laura and James have talked about those already, but in reality what it tends to do is mean that women are bringing claims using the other protected characteristics that are available to them, and it kind of makes sense. So that might be age or sex or even disability, and that's actually tended to be where the most claims have focused, I think. Now, query whether you're happy with the kind of the policy behind it being described as a disability, but in reality the claims have focused on whether menopause symptoms are sufficiently serious to meet the definition under the Equality Act of disabled. And that's where a lot of the case law has focused when those claims have been brought. And we'll look at some of those. But clearly age and sex are relevant as well. And that's how those kind of claims have been framed. We've talked about the future in the Employment Rights Bill, and there is some mention of menopause in the bill, though not a huge amount. It sounds like it's likely that there'll be regulations at some point which may require employers with 250 or more employees, so big employers, to produce and publish menopause action plans. So what they're doing in this area, essentially, to improve things. And there may well be penalties for employers that don't do that. But again, as with lots and lots of the Employment Rights Bill, there's further consultation to follow, and the detail is still pretty light in terms of where this will end up. But the gist of where the government's going with it is that the idea is to improve workplace support for women with menopausal symptoms. So that, I think is a positive. Where it'll actually end up, given that it's effectively just a kind of reporting duty or an action plan duty, we'll see. So looking at some of the claims, and this is where it obviously gets interesting. I suppose that there are a number of claims that have kind of gone both ways. So not every menopause case is successful, as is the case with most tribunal claims, but we are going to look at some of them that have been successful, and hopefully that's useful in terms of, as from the employer side, understanding where these kind of cases have gone. So the first is Rooney, and this was, I think, interesting because at the first instance, so in the employment tribunal at the first stage, the claim actually failed, and the tribunal decided that effectively, because the lady, bringing the claim in this case, was caring, I think, for elderly parents and children, and doing lots and lots of stuff to try and simplify the case quite considerably. They didn't take the view that menopausal symptoms had sufficient impact on her day-to-day activities. Now, that was actually appealed, and therefore, didn't meet the definition of disabled. That was actually appealed, and the Employment Appeals Tribunal decided that the tribunal were completely wrong on that front, and that just because somebody, works through their symptoms and continues to kind of battle on, as it were, doesn't mean that their symptoms don't have a significant impact on their ability to carry out day-to-day activities. So that was actually then remitted back to the to another tribunal, I think, and it was found that in that particular case, her symptoms did meet the definition of disabled. So that's an interesting one to look at in a number of ways, but we don't have time to go into lots and lots of detail on each of the cases. But one where the symptoms were found to meet that definition. Then Linsky and Direct Line is another case that I've talked about in more detail in other sessions, but essentially Direct Line didn't do a brilliant job, let's say, of managing this situation. And of course, very often these kind of situations come down to managers doing this well. And I think there's definitely a lesson around, as we've talked about with lots of this stuff, managers being aware of these issues, being trained and understanding how to manage people generally, but particularly with more tricky issues like this. And effectively, Ms. Linsky was put on a performance management plan, having been a very capable and high-performing employee previously. At least that's what the judgment tells us, and was effectively taken through that process without due consideration of the fact that she was experiencing menopausal symptoms, including, I think, concentration issues and a variety of other symptoms. And the tribunal found that actually the employer in that case had managed it very badly, and that it was disability discrimination, that she did meet the definition, and they awarded her £23,000 for injury to feelings. So again, just an example of a manager and employer not taking due consideration of the impact that menopause was having, and obviously ending up with a pretty hefty award against them. I think that was just the injury to feelings, but I think there were other awards as well, so it was even more costly in that case. Then looking at age discrimination, so not disability this time, but menopause as a feature of an age discrimination claim. In McCabe, you won't necessarily be surprised to hear that she was successful when I describe some of what I think were described as ageist attitudes or the age discrimination that took place. So the claimant was female and was dismissed at 55 years old, and the CEO had told her to calm down, don't let your hormones get control of you, and had also instructed a recruitment agency to find a younger replacement. Now, again, there's lots and lots of detail in the case, but the evidence was that the employer had viewed menopause as an issue of being older, and as a result, it was direct age discrimination, and again, awarded £20,000 in that case. Similarly, and unfortunately, very insensitively, in the Bon Marché case, the claimant experienced harassment and discrimination. And in fact, when you get into the detail of that, it turns out that her manager would make fun of her and humiliated her in front of other colleagues who were all younger, and they would laugh at her. And I think at one point, the manager even called her a dinosaur. So again, not unsurprising that there was a successful age discrimination case, but again, it was very much focused on the fact that the menopause was clearly related to age, and therefore, as a feature of that, was found to be, discrimination. Yes, a few comments in the chat about how shocking it is. Yeah, exactly, and I think obviously there are lots of employers doing good stuff in this area, but it's clear, from some of these cases that there's still some work to be done. Finally, sex discrimination case against BT. And again, it feels a bit like a manager, and to be honest, probably in this case, HR got it wrong because they were involved in the process. And again, female claimant had presented her manager with a letter from her GP confirming that she was experiencing menopause symptoms, and that would very likely have impact on her concentration at work. And essentially, manager failed to investigate that any further as part of a kind of performance management and eventual dismissal process. And I think, again, the judgment highlighted the fact that actually BT had a quite distinct and clear process for investigating medical issues ahead of dismissing, so getting OH involved and so on. And this particular manager didn't. He couldn't really, under evidence or under cross-examination in his evidence, explain why he hadn't in this case. But it was interesting that it kind of became clear that he had made assumptions, I think even based on his own experience of his wife's menopause, and also HR's view on it. And I think there's a lesson there, isn't there, in terms of the fact that this is very different experience for different people, and therefore just jumping to assumptions based on what you might know or what HR tell you is not a great idea. And I think also the importance of medical advice in these scenarios, again, is highlighted as part of that. So again, unsurprisingly, the tribunal found that it was sex discrimination and unfair dismissal in that case. So again, it's a bit of a whistle-stop tour through those, but we thought it was useful just to highlight the cases, the types of cases and the way that they're being framed as we go. And if you'd like to look into those and read up on them in more detail, then obviously you can. Again, it won't be a surprise that I'm suggesting training managers and raising awareness, and I think that's key on a whole load of issues, but including this. taking those medical concerns seriously, not just dismissing them because people don't understand, what's happening. Having clear policies. So we're definitely seeing an increase in menopause policies being introduced in workplaces. But I think the other thing that came out in the comments on my LinkedIn post was that actually just asking people what would be helpful for them is a really important part of this, because actually everybody's experience is different, and therefore even a policy may be helpful, but in reality, if everybody's experience is different, then what they may need in terms of support is likely to be different. So having managers that are able to have those kind of conversations and engage positively is likely to be helpful. I think the other thing, in terms of employers risk assessing these kind of issues, if things, do go bad, is that it's clear, although I've highlighted lots of the cases that were successful, there are a number where actually they weren't successful, either because it was a disability claim and the symptoms weren't found to be serious enough, or actually there were other explanations for why the employer did what they did that weren't necessarily linked to menopause or to discrimination, and therefore it was a different outcome, and each case will turn on its facts, as us lawyers might say. So again, hopefully that's useful. James is going to now pick up on religion or belief discrimination.
Thanks, Nick. I've unmuted successfully this time. Religion or belief discrimination, the reason we're doing a separate section on it is because there are some added complexities that can jump in that don't tend to on other cases related to other protected characteristics, for reasons you will see shortly. But as we did with some of the other slides, we'll take us back to the slightly mundane, the statutory definition of the protected characteristic of religion or belief. And on the slide is what it says. But what's happened over the years is to help the tribunals apply this definition, particularly in cases that relate to philosophical beliefs, is what's called the Granger test. Funnily enough, developed in a case called Granger versus Nicholson. And they're sort of sometimes referred to by lawyers as the fourth and fifth limbs of Granger, because usually they're the ones where the test boils down, because as you'll see, if you read them sequentially, if you're the claimant, it's probably going to be easiest to show that you genuinely hold the belief. And a lot of the argument then focuses on the fourth and fifth, about the cogency, seriousness, cohesion, and importance of the belief, and whether it's worthy of respect in a democratic society and not incompatible with human dignity and conflicting with the fundamental rights of others. But the tribunals and courts work through the Granger test sequentially, and you need to tick all 5 boxes to have something that is protected under the Equality Act. You don't do this with mainstream religions. If the claimant says he relies on mainstream religions, then you get straight to the end. So, bit of context around philosophical beliefs. There's a table of things that, applying that Granger test, have held to have been protected beliefs, unsurprisingly, in the yes column. And then in the no column are things that have not been held to be philosophical beliefs. I'm particularly pleased about the first one. It would seem a bit weird if sort of economic policy could form a philosophical belief. And that's probably why it didn't. But some of the others you might have heard of, I'm sure we've talked about in a previous seminar about veganism being a protected belief in that case. Oops. All right, I picked 2 slides at once. Now, this case is the one that really we want to talk about in the religion or belief sphere. It's a relatively recent case that went all the way to the Court of Appeal, and it added an extra layer of complexity, you may or may not be pleased to hear, as to how we need to consider religion or belief cases. And the good thing is, from a seminar perspective, is that the facts aren't something that you might think are completely impossible to happen in a normal business. So this was a secondary school, farmers' school. The claimant was Miss Higgs, and the chain of events started, or certainly from a disciplinary process perspective, when a parent complained that the claimant, who was a pastoral administrator, had expressed homophobic and prejudiced views on her Facebook page. She ended up being summarily dismissed for gross misconduct and pursued claims of discrimination and harassment before the employment tribunal, and she lost. I wondered, so you're probably wondering the same, why didn't she just claim unfair dismissal? Well, apparently she tried, and she filed it late, so it was dismissed on a technicality over timing, whereas the timing for discrimination cases, although it's still 3 months, the tests relating to when you can get extensions is different. So I'm assuming that she got the extension on the Equality Act claims, but not on the claims under the Employment Rights Act unfair dismissal. But either way, they considered the merits of the discrimination claims, and they did not consider the merits of the unfair dismissal claim in the Employment Tribunal. Now, what I was keen to read in a bit more detail was what the Facebook post actually said, because as Nick said quite rightly, a classic lawyer's comment, cases turn on their facts. So what were the facts? So the post she typed in the bit I'm about to read into Facebook herself. Please read this. They are brainwashing our children. And then she kind of copy and pasted or reposted a big paragraph explaining that government consultation into relationships and sex education is going to be mandatory in secondary schools, and it closes soon, the consultation. And then it goes on to say, for example, children will be taught that all relationships are equally valid and normal, so that same-sex marriage is exactly the same as traditional marriage, and that gender is a matter of choice, not biology. And the post went on, I won't read it all. But at the bottom, the employee actually typed something. Please sign this petition. They have already started to brainwash our innocent, wonderfully created children, and it's happening in our local primary school now. End of post. That was the first post, and that was the one the parent was complaining about. So as I said, that her claim for discrimination and harassment failed before the Employment Tribunal, but it was appealed, and the Employment Appeal Tribunal upheld the appeal and remitted the case back to the Employment Tribunal for reasons I'll come to. But before it went back to the Employment Appeal Tribunal, the claimant appealed that outcome, even though she sort of partially won, to the Court of Appeal, arguing that the Employment Appeal should have gone further and just said you've won your discrimination claim, rather than it sending it back for the Employment Tribunal to decide. And that's where we'll join it at the Court of Appeal. And they did uphold the appeal and do exactly what the claimant wanted, and substitute a finding that her dismissal was an act of direct discrimination on the basis of her religion or belief. I think you can work out what she argued her religion or belief was from the extract of the post that I read out. But what's interesting is the why. So I talked earlier about victimization and separability, the offensive detriment, the comment about the Little Sikh Club, and the argument that the reason for dismissal or the reason for the detriment was the offensive comment, as distinct from the allegation that there was a breach of the Equality Act. Here, it's not exactly the same analysis, but there's sort of a link to it. So the argument being run by Miss Higgs was that it was directly discriminatory for her to be dismissed for manifesting her religious belief. And the school's argument, in broad terms, I'm massively oversimplifying, because the judgment on this case is around about 60 pages of detailed law. So we're not going to go into that much detail because you'll all be bored. But if you were really, really curious, this is all online if you wanted to read the judgment. The reason it's more complicated is because of the interaction between the Equality Act and the rights that people have under the European Convention on Human Rights. So Article 9 of the convention, not the contention, is the freedom of thought, conscience, and religion. Article 10 is freedom of expression. Now, Article 9, the freedom of thought, conscience, and religion, is what we call a qualified right. And there's a subpart of the article, Article 9(2), that says a person's freedom to manifest one's religion or beliefs shall be subject only to such limitations as are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedoms of others. So what the Court of Appeal was saying is that you have to consider the Equality Act in that context. And the second bullet point summarises their sort of main conclusion, which is where an employer is taking action against an employee because of what they consider to be the objectionable way in which they have manifested their belief. In this case, the reposting of the message on Facebook with the text added at the top and the bottom. That action will only be lawful if the employer can show that it was an objectively justified, proportionate response. So it's not enough for them to say that it wasn't the fact she held the views, it was the way that she expressed them, unless they can say that their response to the objection, their objection to the way she manifested it and their response to it was justified. And the justification test is the same, broadly speaking, as the one that Laura alluded to right back at the beginning on indirect discrimination. So you look at proportionality. Now, the reason Lord Justice Underhill didn't think that it was worth sending the case back to the Employment Tribunal, or why he didn't think it was correct to do so, is he thought that it was unquestionably, based on the facts as already found in the Employment Tribunal, a disproportionate response to dismiss the employee for these comments. And he focused on a number of key reasons, which I've listed out there and are worth looking at. The first is his conclusion that the posts weren't grossly or gratuitously offensive. Now, those of you that on this webinar might have thought that those posts were offensive. Lord Justice Underhill didn't downplay the comments too much. He had a very detailed analysis, but he drew analysis to essentially things that are worse, or he gave examples of other cases where beliefs have been manifested in ways that are a lot more offensive objectively than were done in this case by this teacher. Oh, sorry, I don't think it was a teacher, was she? Pastoral administrator, I think that was their job title. The second point they focused on, the Court of Appeal, was that the language that the school objected to was not her own words. So essentially the bits I read out at the start, the stars bit that she added to her repost, they weren't so fussed about that. They were more focused on the bit that she'd cribbed from someone else, and they placed some weight on that. The next one's, I think, a good point that has a lot of general application when you're doing just bog standard disciplinaries. No evidence of reputational damage. Sometimes employers are very keen to dismiss because of reputational damage, but when you end up in a tribunal, that's often challenged by the other side, saying, well, but what was this reputational damage? And the problem here was that the Miss Higgs had posted on Facebook using her maiden name. There was no reference to the school. And as far as anyone could tell, it was just this one parent who'd complained is the only person that seemed to have read it, certainly as far as the school knew. So it was very difficult for them to say they'd actually had suffered reputational damage. The other point that they focused on was that there was no evidence that the work of the person at the school would be affected by the views. And I think this is a critical one. Firstly, she was expressing views about the teachings in primary school, but they were at a secondary school, so it wasn't related to her work as such. Secondly, there was no suggestion or any evidence at all that she brought her views to work, so to speak, in that she wasn't passing them on to the pupils or treating the pupils. People probably don't call that anymore, students, I should say. There was no suggestion that she was influencing the students or even attempting to with her views. It was just a private post that, as far as the school seemed to know, hadn't gone any further than that. The other thing that the tribunal rightly focused on, in my view, was that this employee had a clean record, that essentially she did nothing wrong, and this post was the first time that she'd been involved in a disciplinary process. And they thought that was relevant to considering whether it was justified to curtail her Article 9 right for freedom of thought, conscience, and religion. And the final one also had a nice point that has more wider impact. It was this point about remorse, or conceding that you were wrong, or showing, as the term the Court of Appeal used, insight. So one of the things that the school held against her in the internal disciplinary process is that she wouldn't show sufficient remorse in saying, I shouldn't have done that. I shouldn't have expressed my views in such a way. And the point Lord Justice Underhill made, which I thought was a very sensible one, is that when people feel very strongly about something, it's especially in the beliefs sphere, they're very unlikely to say, I shouldn't have said that, because they feel very strongly. And so it's perhaps not surprising that she didn't show the sort of level of remorse, or however you want to phrase it, that the school wanted. But the point of more general application that he made was that whilst that can be a factor when you're considering seriousness in disciplinary cases, whether the person is likely to do it again, whether they showed remorse, that's not going to be a factor that changes something that's clearly not a dismissible offence into a dismissible offence. It might be where you've got a potentially dismissible offence or a dismissible offence and the person shows remorse, you might say mitigate the sanction down. But where something is clearly not, in the eyes of the tribunal, something that you could dismiss someone fairly for, or would be a proportionate response to the conduct, the fact that they're not apologetic about it, it isn't enough to then say, well, we're promoting it to the level of seriousness of dismissal. So I thought those were all interesting points of analysis in this case. So the key takeaway is this added complication added by the European Convention. And if you're looking at a case where you're going through a disciplinary process where someone has manifested their beliefs in a certain way that might upset others, you have to make sure that any treatment or disciplinary sanction is justifiable. Otherwise, you can potentially fall foul of a direct discrimination claim. And that brings us to an end for today.
If you'd like to connect on LinkedIn as well and just keep up to date on some of that stuff, hopefully you can see the slide there if you missed it at the beginning, and you can scan those QR codes and keep in touch with the team. Thanks very much, everyone.